Good morning. It looks like it's about 10:01, so we'll probably give about one more minute for attendees to arrive, and then we'll go ahead and get started. Great. Well, it looks like it's about 10:03, so I think we'll go ahead and get started. Welcome to the webinar. This is the 2017 Regulatory Update, a little more litigation, a little less regulation. The subtitle was a recent addition to the presentation, but I think it just seems fitting given the current climate, and we'll talk a little bit more about that today. So before we jump in, we've got a ton of information for you today. So I want to go through just a few quick housekeeping matters, and then we'll get started. So first, thank you again for joining. I know you all have busy schedules, but we really appreciate you taking the time out of your schedule to join today. First, my name is Bonnie Treichel. I am a senior consultant here at Multnomah Group and the head of the Technical Services Committee. I also have a co-presenter today, and I'm really excited to have her on the line as well. Her name is Haley McLaughlin. She is a benefit analyst and also a member of the Technical Services Committee. So I think many of you on the line have had the chance to probably work with Haley before, but I'm excited to have you get to hear her today present some of the information as well. So a couple other things, you will find that your line is muted. If you need assistance throughout the webinar, please use the question pane on the right-hand side of your screen to enter any comments, including any technical assistance you may need with audio or visual. Also, there will be a time for question and answer at the end of the webinar, so if you have a question throughout, please feel free to enter that throughout the presentation, and then we will get to that at the end as well. Finally, you may also notice that there is a handout that's also in the right-hand side of your screen. So please be sure to check out the handout, which is a narrative version of the regulatory update, and that was dated September 1st. I think you will find that some of the information has been updated as we'll talk about throughout today's presentation. And finally, today's session is being recorded, so you will receive a copy of today's slides via email along with a link to the recording of the session. So with that, I will go ahead and get started and move on with an overview of what we'll be covering today. So once again, on today's webinar, there's really way too much to cover everything that was in that narrative version that is in the handout pane. So we picked some of what we find to be the most relevant topics to the plan sponsors that we're working with. If there's something that's in that narrative version that you'd like to cover in more detail, please don't hesitate to reach out to a Multnomah Group consultant, and we're happy to go over that and how it impacts your plan. But what we'll talk about today, one of the things we'll cover initially is just an overview of kind of what's the political climate and how does that impact regulation or maybe the lack of regulation. And then we'll move on and we'll talk a little bit about litigation. So I think one of the themes you'll find throughout today is that there's more and more litigation. And how does that really impact your plan? Haley's then going to talk to us about state-run retirement plans. I think you're seeing more and more in the news about state-run plans, what different states are doing, and even starting to hear about what different cities are doing from a state-run and city-run retirement plan aspect. Then I'll take you through a little bit around the fiduciary advice regulation, also known as the fiduciary rule. And some of you may be tired of hearing about that, so we'll keep that pretty brief and just really keep it to what's the current state of the fiduciary rule and how does that impact your plan, what should you be doing today. We'll also talk briefly about tax reform. And on the tax reform side, really what we'll talk about is how do potential tax reform proposals impact retirement plans? And what does that mean for you as a plan sponsor? And then Haley's going to take us through some of the changes as they relate to defined benefit plans. So if you've got a defined benefit plan, definitely want to tune into that part of the webinar today. And then we'll really round out with some of the things that are more what I would consider on the horizon in retirement. So some topics that are out there, it's not regulation that is in effect today, but some topics you really want to be paying attention to because they're coming in the future. And then of course we'll end with a question and answer portion. So definitely as we go through the webinar, have your questions ready and be entering them in that right-hand pane so that we can get to those at the end. So with that, I'll go ahead and turn to the political landscape, because I think the political landscape, from my perspective, shapes a lot of the regulatory update for this year. So I gave you a second there to kind of check out some of the graphics here. I think, you know, Bloomberg recently had some statistics, which we've shown on the screen, regarding the pace with which this administration has made progress in the Department of Labor and the EBSA. And when we say EBSA, we're referring to the Employee Benefit Security Administration. So the EBSA is a department under the DOL, and there's 21 other departments under the DOL. So the EBSA is just one of them. So when you think about retirement plans and where regulation is coming from, it comes from the IRS and the Department of Labor, whereby the EBSA is doing pretty much most of the work on regulation for the DOL. So I think we included these stats to help you to really kind of see where regulation is moving or how fast it's moving given the leadership and the pace with which the leadership was put in place. So for example, if you take a look at that middle graphic, that's looking at the Labor Secretary and the appointment of the Labor Secretary or the head of the Department of Labor, which took almost 100 days, which is about 3 times as long under this administration when you compare it to the last administration. And there's a cause for that, and that was that the first appointment fell through. So that was Andrew Pudzer, and that fell through. And then we had Andrew Acosta, who's the current Labor Secretary. But you know, there's certainly reasons for that, but when you think about it, if you're missing your head, you're missing leadership, and then those other appointments can't come through as well. So that kind of leads to that other graphic on the far right-hand side, which is the head of the EBSA. And this graphic, we could probably update that like today actually, because within the last few days, the White House came through with their appointment of Preston Rutledge. So again, we see we're getting these appointments, but they're taking much longer. And so when you don't have that leadership in place, we see that things can't be accomplished. And when you don't have the leadership to put those key components in place for things like the fiduciary rule, obviously some of the other regulation that we would typically see, that's not being accomplished as well. So just a little flavor of what's going on in DC, which kind of sets the tone for, if you've tuned into past regulatory updates, a lot of it in past years is all about one regulation after another. And this year you'll see a little bit of a different flavor because of kind of the taste of what's going on in Washington. But alas, if we flip to the next slide, you'll see where the regulation may have lagged, the litigation has picked up and continues to pick up. So this slide is just showing some data that comes from Groom Law. It was analyzed by Investment News, and it shows the pace with which fee litigation lawsuits, so these are fee litigation ERISA lawsuits, the pace with which they have been increasing since 2013. So it shows 2013, 14, 15, and 16. 2017 is not included yet, but I think through our discussion today, you'll see that in 2017, it's not slowing down at all. So that just kind of gives you a taste of what the current landscape is. And with that, I'll go ahead and turn to our first real topic for today, which is the litigation update. So what's going on with litigation? As I mentioned, the pace of ERISA litigation, it's not slowing down. In fact, one of the things is that the scope, arguably, of these cases it's expanding, and we'll talk a little bit about that. But the good news is that for plan sponsors, we saw a period of time back in the mid-2000s and late 2000s where every case seemed to be a settlement, and it seemed to be a settlement that was paying large sums of money that were always, a loss for the plan sponsor team. So that trend is somewhat shifting where plan sponsors aren't losing every case anymore. And so that's a really good thing for plans and plan sponsors from my perspective. So for example, one of the cases I included is the case of the Chevron case. And that was a case in the Northern District of California brought by a well-known firm, Schlichter Bogart, and that's a firm out of St. Louis. I give you that name because they're really well known for bringing this type, and for a while they were really doing this case. This Chevron case is really significant because they filed once, refiled, and then lost again. There were two major issues that were discussed in the case. So one was an issue dealing with money market funds versus the use of a stable value fund. The other issue was the use of lower fee investment options. Arguably, it was the argument made that they should have used, for example, separate accounts or collective trust. The court, throughout the case, both times, even on the second refile, and said that there weren't enough facts alleged, and so because they didn't have enough facts to plead the case, they threw it out. So the defendants, the plan sponsors, they won the case. I think it's important for plan sponsors to see that while the plan sponsors won that case, they didn't win necessarily on the merits. They won because of the lack of facts. So while it is a win for the plan sponsor team, it's not necessarily a win on the actual merits of each of those individual claims. It's that there was a lack of facts, and that's why they won. But it's still a great win for plan sponsors because before that time, they weren't even getting that far. They were just settling on each of those cases. So I think that's a great example of how plan sponsors are starting to kind of turn the table and win some of these cases. I'll move on to a couple other cases. The Intel case, I also included that case. I think it's also really important because, again, it's a win for plan sponsors, and it symbolizes the importance of providing required disclosures. So I'll kind of be brief on this case, but in a nutshell, it was thrown out on statute of limitations grounds. And essentially, because the disclosures were provided, they were able to show actual knowledge And had they not done that, the statute of limitations would have been longer and it wouldn't have been able to be thrown out on those grounds. So the lesson learned there is provide those disclosures such as the summary plan description. You could then later be able to use those in litigation as basically a shield and potentially get the case thrown out. The last case I'll briefly mention here is the Barrett case. This case is important not because of the last two cases where I'm demonstrating the win for plan sponsors. This case, it's just important to show the scope of fee litigation and how it's expanding. So I mentioned the firm earlier, Schlichter, Bogart, and St. Louis, and we talked about that, you know, it's this well-known firm. It's well-known because it's filing this type of case, this ERISA fee litigation case. In the Barrett case, the firm that filed the case is totally different. It's not the Schlichter firm that's known for filing this type of case. It's a firm that's totally off the radar from my perspective because they weren't known for filing ERISA fee litigation cases. So I think the Barrett case somewhat symbolizes that other attorneys are starting to throw their hat in the ring and file these types of cases. So again, the Barrett case doesn't have any other really big symbolism for me other than, hey, other attorneys are starting to learn how to file these types of cases, which means it demonstrates a proliferation of these types of cases more so than in the past. One of the other things that we're starting to see, and we've had some blog posts in this, are that some smaller plans are starting to be the targets of some of this fee litigation. So in the past, it was typically big Fortune 500 companies with really big plans because the economics of the lawsuit made it such that you wanted to file against really large plans because that's where the money would be. But we've also seen that even, for example, I believe it was within the last 6 months that we saw a $3 million plan that was the target of a lawsuit. So I think that really symbolizes, again, that scope expanding. So really, I think the takeaway here is that no single plan is protected or bulletproof. It doesn't matter if you're the $1 million plan or the $100 billion plan. If you have a plan, you're opening yourself up to liability, and as such, the more that you can use best practices to avoid liability, the better off you're going to be. So with that, I'm going to turn to some more what I'll call high-profile cases because these are the cases where we've had the Supreme Court either weigh in or say, no thanks, we don't want to weigh in. So really briefly, I'm not going to spend any time on this, but want to mention that if you have a church-affiliated plan or think you do, you might want to check out the Advocate Healthcare case. That was a case that came out this summer, and so that's one where you really would want to talk to your ERISA counsel about how that case affects you or impacts you, but that's the Advocate Healthcare case, and we saw the opinion on that over the summer. The next one that I'll briefly touch on is the last one that's mentioned on the screen, which is Tussey versus ABB. And that's another case that's been going on, I want to say, nearly a decade. And we just heard within the last couple of weeks that the Supreme Court declined to hear that case. So I think it looks like maybe in this coming year we won't really see the Supreme Court hearing any ERISA cases. The Supreme Court declined to comment on why they weren't going to be hearing it, but it doesn't look like they will hear the Tussey case. And then finally, the case that's in the middle of the screen, Tibble versus Edison. I think for plan sponsors, this is a really, really important case. And, you know, it went on for almost a decade, I believe actually over a decade. It was heard by the Supreme Court back in 2015, and then it finally ended back in the district court this year. The gist of it is that the complaint focused on about 17 mutual funds that participants, it was a class action suit, argued should have been institutionally priced rather than retail priced. And so the holding really from the Supreme Court was that the justices all unanimously ruled that plan sponsors have a continuing duty, and I'll say that again, that plan sponsors have a continuing duty to monitor investments and to remove imprudent ones. And so really, I have like a couple, I'll say, couple key takeaways for plan sponsors from this case. So one is meet regularly. You can't meet that continuing duty requirement if you're not meeting regularly. So you've got to meet regularly so that you can remove investments when it's necessary. Two, you've got to document decisions. So for example, if you're not going to remove an investment, you've got to document why not. It's not that the Supreme Court said you must do X, Y, and Z with respect to X investment. If it's that you've got to document why or why not. And then finally, prudently select and monitor and replace investments and share classes. So share classes, came up a lot in that case. And I think sometimes when we're working with plan sponsors, we see that the share class piece is a missing component. So prudently select, monitor, and replace both investments and share classes. So with that, I'll go ahead and move on to the next area of litigation. And I promise this whole webinar is not about litigation. So it's just a really big topic of the webinar because it's such a big component for plan sponsors right now. But the last area that we'll cover on the litigation front is going to be the colleges and universities and the cases there. So briefly, I'll just touch on that. The point we want to make here is that back, let's see, August 2016, we saw the Schlichter firm as well as another firm start to file cases against colleges and universities. So some of the premier colleges and universities across the country. We saw that all the cases were filed. Then we had several motions to dismiss, which were heard, and now many of them were ruled on. Every day we're seeing, the cases start to proceed. What's, I think, critical to understand about the cases is that none of them have settled at this point. We have one that was dismissed, so University of Pennsylvania was entirely dismissed, but in all the other cases we have a lot of cases that are proceeding, so these are the ones that say dismissal denied, and in those there's usually some claims that move forward and some claims that are dismissed. And if you look at all these different cases, most of the claims are substantially similar across the cases, and when you look at the different outcomes of the motions to dismiss, sometimes different district courts are ruling in different ways. So it seems to me it's setting up some sort of circuit split between the different courts. So it'll be interesting to see how it plays out. But the takeaway for plan sponsors for the cases against colleges, and universities is that there's not a single outcome from these cases. So I wouldn't say, oh, well, because this happened in the University of Pennsylvania, we should do X or we should do Y. I think there's too many different outcomes at this point to see, and we'll have to wait and continue to monitor to see what the real outcome will be across all the cases. So stay tuned on that one. So with that, I know that's a lot on the litigation front. Thanks for sticking with that. I'm going to actually turn it over to Haley, who's going to go through a discussion on the state-run retirement plan front.
Thanks, Bonnie. Hi, everybody. This is Haley McLaughlin. I'm a benefit analyst here at Multnomah Group. So we're going to talk about state plans. I think that you all know that there's a broad concern that people aren't saving enough for retirement. And one of the biggest hurdles to savings is access. And we've seen several studies come through that show that workers are more likely to save for retirement through their workplace than on their own. And that makes sense. Workplace plans can have great things like auto-enrollment, and inertia really is our best friend in getting people into retirement plans and saving and able to retire on time. So we have several states that have stepped in to help close this savings gap. We've also seen a few cities attempt it. A few of them are further down the line than others. That includes Oregon, Washington, California, Illinois, and Connecticut, I think are our top ones, but it's evolving. As we see this go through, we broadly have two main types of programs emerging. One is, like the case in Washington, it's a marketplace approach where individuals and businesses that don't have a plan can comparison shop for retirement saving plans and options and gather information on retirement plan savings. This is a totally voluntary program and it aims to really just bump up people's understanding of retirement plan, both individuals and small businesses. And so we see that with Washington. I think New Jersey has rolled out theirs as well. The other thing that we see is with Oregon. They're leading their way with their Oregon Saves plan. It's an example of what I'm calling the second type, which is an auto-enrollment. It's an IRA for all employees who don't have access to a plan through their workplace. It would be mandatory for employers who do not offer retirement plans, and it has a planned phase-in that would impact all employers in Oregon by 2020. So the mandatory and the auto-enrollment are big features, and they really distinguish Oregon's from a lot of other state plans. There are already a few roadblocks to these programs. As you know, under the Obama administration, the Department of Labor issued some guidance to support these programs, saying that they weren't subject to ERISA. The guidance was then pulled back under the Trump administration. Oregon decided to continue forward with their plan and began their pilot phase in July of this year. And then late last week, a suit was filed that may put a halt to this Oregon Saves plan. The program currently would require all employers to report whether or not they offer a plan. They'd have to log into the website and say, this is who I am, and yes, we offer a plan, or this is who I am, and no, we don't. And the suit is against this required reporting. This continues to be a developing story, as do all of the other state plans, and we're keeping an eye on it. Either way, we don't foresee many consequences for current plan sponsors. These state plans are not a replacement for that. They're meant solely to complement those existing plans and give individuals that don't have access more options. With that, I think I'm turning it over to Bonnie, who's going to discuss a different evolving story, which would be the fiduciary rule and advice regulation.
Great, thanks, Haley. On to the fiduciary rule. So again, I won't spend long on this because I think most of you are really aware of what the fiduciary rule is. So remember, the fiduciary rule is a regulation that expands the definition of advice such that many additional financial professionals are now considered a fiduciary under ERISA Section 321A2. And one of the big things about the rule is that it also applies to IRAs. So that really expanded the scope of fiduciary and to many new financial professionals. So the rule became applicable on June 9th, 2017. So in other words, the world got a lot more fiduciaries in June. However, we are in what's called a transition period, which means that some of the provisions of the rule, namely the best interest contract provision, those are not yet in effect. So currently we have a proposal that it had a comment period, which is now since closed, but that proposal was to extend this, what's called the transition period that we're in, so that the current rules will play out until July 2019. And really the reason for that is I believe that it gives more time to figure out for this administration what they're going to do. So are they going to keep the rule as is, or as kind of that third bullet point alludes to, are they going to kick it over to the SEC? Are they going to do something in collaboration with one another, which several people have suggested they should, so that the agencies are working together on one cohesive standard. And we do have the SEC stepping in and saying that they're working on a standard for financial professionals and that they are working together with the DOL. So one of the key things to know is that the proposal to extend to July 2019 has not yet come out as a final rule, but it's the speculation is that that's what will happen. So what does all of this actually mean for you and for your retirement plan? Number one, I think it means that there's a lot more fiduciaries in the world, and some of these new fiduciaries might not even really realize they're fiduciaries. Number two, you should understand who you're working with. So really make sure you know from a plan perspective, are the providers you're working with, are they a fiduciary, or are they working with you in a non-fiduciary capacity? And then make sure that you review the contract and the 408B2 disclosure of those providers to confirm what they say is correct. Are they fiduciary? Are they non-fiduciary? And does the service agreement actually reflect that? Because that's part of your duty to monitor service providers. And then third, I would say just understand your obligations under the rule. So for example, your obligation, it includes monitoring of service providers and what they're putting out in front of your participants. So make sure that you understand if some record keeper vendor is coming to your campus or your office building and meeting with participants, make sure that you understand what they're giving those participants and that you've reviewed that in some way. And then finally, be prepared. I think some of you have likely seen some new disclosures or contracts. I'm working with a plan sponsor, for example, and they have a service provider who did a new service agreement that has additional language as a result of the fiduciary rule. I think that's something you'll probably either have seen or will continue to see. So definitely don't hesitate to let a Multnomah Group consultant know if you have questions on that. We could talk about, and we have done several webinars just on that topic. There's a lot there, and I think those are the key takeaways for today. So I'll turn to our next topic. Again, a really big topic, but we'll keep it really brief for today. This next topic is on tax reform. And what we really want to focus on is how tax reform could impact retirement plans. So one of the big agenda items for the Trump administration was tax reform. And we saw on September 27th that the Trump administration rolled out their blueprint or proposal for tax reform, which arguably, from my perspective, was intentionally pretty vague with respect to how retirement plans will be handled under the new tax scheme. And maybe that wasn't intentional, but it just, you can't put everything in it perhaps. So, anytime that tax reform is discussed, retirement plans are often an attractive target. And the gist is that the government scores budget proposals with a 10-year window. And when you think about retirement contributions, they're tax-free going in and taxed on the way out. So this is in a non-Roth. So from a 10-year perspective, by limiting or eliminating the deduction on the front end, so when it's going in, budget scores show that deductions for retirement plan contributions cost the government around $100 billion annually. However, that money is gained on the back end for the government when the money is taxed at the withdrawal. But this deduction, when you think about it, it's different from like mortgage interest or health insurance deductions. Those are never taxed, but the point being is that retirement plans, they're an attractive target because when you do a 10-year score, retirement plans look really good. That $100 billion annually could look really, really good. So one of the there's two proposals that are oftentimes tossed around or have been tossed around most recently. One option could be, and this has been talked about a lot in the retirement industry, is that some or all employee deferrals could be mandated as Roth. The second option is that there could be the deduction for retirement plan contributions would just be limited. So in that example, instead of the $18,000 annual limit, perhaps that goes to $5,000 annually. And I'm not saying it would be $5,000, that's just an example. But by limiting that, again, that could be a really attractive way to generate some revenue essentially. So both of these options have been discussed. It's really unclear as to what the final tax reform package would look like. And I think the takeaway here at this point is that it's too early to tell what that final package will look like, and there's really a long road to see if anything will actually come to fruition from a comprehensive tax reform package. Today, we saw the proposal from the administration in late September. Now it goes to the House Ways and Means Committee to take next steps, and then we still have the process in Congress. So I think we're a long ways from seeing anything come to actually impact your retirement plan, but for plan sponsors, certainly something to continue to monitor to see if there will be any changes to the actual day-to-day retirement plans and how that looks for your participants. So with that, no action needed from a tax reform perspective. Continue to monitor, and I'll go ahead and turn it back over to Haley. She's going to take some time to talk to us about changes for defined benefit plans.
Thank you, Bonnie. Yes, defined benefit plans. So in the past year, we've gotten some new finalized regulations and some new proposed regulations from the IRS that will affect defined benefit plans. About a year ago, the IRS released final regulations that allow plan sponsors to offer a wider variety of distribution options to participants. Previously, participants could annuitize their retirement, so receive those lifetime income checks, or they could take a lump sum distribution. This created some concerns that we usually see in defined contribution plans, that people will outlive their money when they're taking this lump sum. So to solve that problem, the new regulation allows for split distributions. So a participant could opt to annuitize a portion of their benefit and take the rest as a lump sum. So they could do 75% annuitized and 25% as a lump sum, or really any other option under the sun. Plan sponsors can choose different steps, or if they really wanted to, you could do any kind of split you wanted. Shortly after that, the IRS proposed some new regulations. These have not been finalized as of this date, but the proposed regulation does two main things. One, it clarifies some of the mathematics and the assumptions for the split distribution, and then sort of the bigger piece is that it updates the mortality tables, which are used to calculate minimum funding requirements and minimum lump sum distributions. And so those mortality tables are used to find the present day value of all of their future benefits. The effect on this change obviously varies based on specific plan circumstance and participant demographics. But really, really broadly, many plans would see an increase in the minimum funding requirements and minimum value for lump sum distributions. So this is supposed to take effect for plan years starting in January 1, 2018. But we haven't seen the finalized version yet, so that date is still a bit up in the air. Additionally, in some late-breaking news, on October 10th, the IRS issued updates to 2 revenue procedures for DB plans. These will be published in the Internal Revenue Bulletin on October 30th, so we are absolutely looking forward to digging into those. If you're interested in adding that split distribution option to your plan, the IRS over the summer released some model amendments for plan documents, and so those could be used to add this option to your current plan. The mortality table update has also been expected for quite some time, and so actuaries have already been putting these into some of their models and their calculations. If you're unsure about these changes, or if you're interested in adding that, you should speak with your record keeper, your consultant, and definitely your actuarial team on these options. So now with that, I'd like to move on to what we see kind of on the horizon for the retirement plan marketplace. These are things that are maybe happening in the future that we're keeping an eye on. First, determination letters. The IRS has been modifying their procedures governing determination determination letters for individually designed plans. Now they will only issue determination letters upon initial plan adoption and termination, and that eliminates the 5-year cyclical program. Then for 403B plans, the IRS began to roll out their approval for prototype and volume submitter plans over this summer. This is a list of plans that have received an IRS favorable opinion or an advisory letter from the IRS, which means the IRS has determined the plan document satisfies their requirements. Then second, the Department of Labor and IRS announced a long-term project to modernize and improve that great Form 5500 and has released some proposed changes. At this time, no rule has been announced, and so we keep an eye on that. Hopefully the 5500 will be better than ever. Third, the Department of Labor has given some guidance for default options and retirement plans. The Department of Labor issued a letter to TIAA, which stated that lifetime income products may serve as default investment options in a retirement plan as long as certain requirements are met. This gives greater fiduciary protection to plan sponsors who want to take advantage of this option. But it's really important to keep in mind that each case is unique and it is all dependent on circumstance. If you're interested in how these changes may affect your plan, please discuss it with a multi-member group consultant or your record keeper or experienced ERISA counsel. So, Bonnie, I think you have some additional topics we're keeping an eye on?
You bet. So for those who are sticking with us, we've got 2 additional topics to round out the presentation today, and then we'll open it up for question and answer. So the last 2 topics we wanted to cover, one is auto portability, and then the last one is just cybersecurity. So auto portability, most of you are probably familiar with the idea of what's called like force outs or small sum distributions, and this is sort of what I would consider like an opposite concept. So this is the idea of routine and automated transfer of a terminated employee's account from an old employer to their new employer. So instead of like forcing it out to an IRA, it's going to get pushed to a new employer. So this is just a concept that was developed by the Retirement Clearinghouse. I haven't seen it actually play out yet. I haven't seen that actually working. I believe what's happening right now with this concept is that they're trying to get some traction with regulators and with Congress to start to roll that out, but I haven't actually seen that play out yet. So stay tuned on that concept. For now, I think people are still using and continue to use as a best practice force outs and small sum distributions, that concept. But be on the lookout for auto portability. You might see that coming to a retirement plan near you soon. The other last topic that we just wanted to touch on briefly is cybersecurity. So you all are seeing this every day in every area of your work. Just keep this in mind as it applies also to the retirement plan. I've done a couple of blog posts on this recently as it applies to your responsibility to monitor service providers, and then also some tips for just reminders for plan participants. One other thing that happened recently is that the Spark Institute, they recently announced that they're coming out with, and I haven't seen these actually rolled out yet, but they're working on new industry best practices for how record keepers should report their cybersecurity capabilities to plan sponsors and to plan consultants. So again, something to just be on the lookout for. But with all of these things, continue to watch for more blog posts, webinars, white papers. Talk to your experienced ERISA counsel about this, and also I know the vendors or other service providers also are working on a lot of materials to help keep you informed about these sorts of topics. So with that, I think that basically concludes the prepared remarks that we had today. I'll give people a couple of minutes while we turn to the Q&A section so that we can start to hopefully field a few questions. I know that, let's see, it looks like we might have a couple, so give me a second to start to read them, and then we'll start fielding some of the questions. One question that came in already was a question of, what caused, let's see, the first question is, what caused all of the fee litigation lawsuits to start and or to continue? That's a really good question. And I don't think there's a single answer for that. Off the top of my head, I think there's several factors that may have led to the continued growth of fee litigation lawsuits. I think that, one reason I see often cited is that the 2012 regulations, so the 404A5, so those are your participant disclosures, as well as the 408B2 disclosures, I think that those both led to more information about fees. So when we talk about people having information about fees to be able to file lawsuits, I think that those regulations help to increase awareness about fees, which also then can lead to more litigation. I think also the widely reported settlements that started with those Schlichter cases even as early as 2006 against some of those mega 401k plans, that also would tend to lead to additional litigation. And I'm sure there's other factors as well, but I think those are a couple off the top of my head. I'll go ahead and it looks like we've got some other questions. One of them, let me see, I think one of them is about the plan documents. So one of them is, when will 403B sponsors start adopting the 403B plan docs that have been blessed / pre-approved by the IRS? And I think that's a fabulous question. Haley, feel free to jump in. My initial thought on that is that if you take a look at the IRS website where they have provided their approval based on a vendor by vendor basis. So it's not like they approved all the vendors at once. It was on a rolling basis that they were approving and updating the website for which vendor was approved. And so that's going to be on a vendor by vendor basis as to when those plan sponsors are going to be able to start using those documents. So for example, I know some vendors, some 403B vendors have their document approved, they've got a process in place, and they are now ready to start the process, not actually at the finish line, but start the process to move people to the new document. So the action item for a 403B plan sponsor would be ask your vendor, 1, are you approved yet for that new document? 2, what is your process? And 3, what is your timeline? Because some might say, hey, we're not even approved yet. Some might say, yes, we're approved, but we're a year out, and you have until 2020 to get that done. And if you have any questions or need help with that, the Multnomah Group consultants are helping a number of clients work through that process, so that's a great question. Let me see if we've got some other questions here. Let's see. So here's a question about 338. So the question is, if a vendor becomes a 338 fiduciary, will the plan sponsor be removed from all risks associated with investment monitoring, including performance and fee benchmarking, share class selection, etc.? I'm assuming the only duty risk from the plan sponsor perspective in that scenario would be to monitor, document how the 338 was selected. Yes, great question. So you want to make sure in your contract that you document, that your contract is set up the right way. I think that was an issue with 316 sometimes, is that you didn't quite contract it right and you thought you were hiring something that you weren't. But in the 338 context, I think it's pretty straightforward. If you hire a 338, you're going to be hiring someone who's going to do the selection of the investments, the monitoring of the investments, the replacement of the investments. And when you're doing that, that's also going to include share class. So the only thing that you would still have liability for with respect to investments would be to monitor that 338. So that's a fabulous question. Your responsibility is just for the monitoring of the 338. That being said, you need to make sure you are doing the monitoring component and documenting that monitoring component. But when you're doing it for the investments, that would also include share class, because share class would be a part of that. So that's a great question. The other thing to keep in mind, though, and sometimes where people run afoul there, is that they think, well, I've hired a 338, so I don't have to do anything. The 338 component, that's only on the investments. You still have what I would consider two other categories of responsibilities, which is one, all of that kind of administrative work, and two, all of the selection and monitoring of service providers. So kind of two other full categories of fiduciary responsibility that you have not outsourced to. But with respect to that specific question of what happens when you hire a 338, you're hiring them for the selection, the monitoring, and the replacement of the investments, and that would include the share class. So you just need to work on that monitoring component. Great question. And I think that that wraps up the questions. I'll give it another minute to see if anyone else submits any other questions. Really great questions, and thank you so much for everyone who's joined today. Haley, any other kind of concluding remarks before we wrap up?
You know what, Bunny, I think that your answers to those questions were fantastic. It's really an interesting topic, and a lot of the things on this webinar have been, let's wait and see. Let's see if we get more information, and then we can move forward. But I think that this has been a pleasure.
Great. Well, it doesn't look like we have any more questions. We'll go ahead and conclude the webinar. Once again, thank you to everyone who joined today. Haley, thank you so much for joining and co-presenting today. Everyone, please feel free to be on the lookout for a recorded version of the webinar along with the handout, which is the narrative version, which includes additional topics. And if you have any questions, don't hesitate to reach out to a Multnomah Group consultant.